Hello friends, welcome. Friends, we all are worried about Vodafone Idea because the recent series of events has not given any confidence to the shareholders who have invested in Vodafone Idea that Vodafone Idea will be able to revive, right? So there are a lot of questions, which have been raised by various stakeholders analyzing the company. Some people are saying the rumors have been spread that the DOT is going to help. Some people say the DOT is going to help. I did a video to kind of explain that how moral responsibility lies with all the stakeholders, including the operators, and therefore DOT loses nothing but make an attempt to test the water whether Supreme Court issues a contempt notice, or if they don't, then this whole issue can be managed very easily. And I'll paste the link of that video in the description, and you should watch that video, which gives a very high level overview of the situation as to why DOT should help, right? But irrespective of what we have done in past and what the situation is that we face today, let's analyze the situation if Vodafone Idea has to go to NCLT, because none of the provisions that we have visualized are applicable for them. They are not able to get loan, which they are trying to do right now, because this article came up in the newspaper on 23rd May 2023 that they are trying their level best to get money, because they need money not only to pay for AGR if the government does not give them relief, but to do capex. Without capex, they will continue to lose customers. So today's video will be dedicated to Vodafone Idea and to analyze if Vodafone Idea goes to NCLT, what kind of repercussions that we are going to see for Vodafone Idea and for the sector, and what is responsible for that outcome. It is not about AGR, friends. It is about certain things which are larger than the overall picture that we are seeing before us, which nobody is talking about. So in this video, we are going to talk about things which nobody is talking about, that what led to this current situation. And friends, you will be surprised to find out as I analyze this whole issue in this video that this situation is a very big problem. And this problem is a larger policy framework that India has built upon itself, and how there are decisions which are taken by the policymakers and the corporate bodies, which leads to some such kind of outcome. It is not just about Vodafone Idea. There are many different cases that we have seen in the past, and which is because of the circumstantial outcome of the overall ecosystem that we have developed for ourselves. So let's go to the presentation, and this presentation is going to be very useful, and you will find this discussion very interesting. And therefore, this discussion, at the end of the discussion, friends, you will be able to realize that what kind of measures that we need to take to prevent such situation going forward taking place in the future, and why India's growth rate is not picking up from the level that we have. It is nothing to do with talent. It is nothing to do with our capability. It is to do with something much more fundamental, friends. So let's look at this. So this video is not just about Vodafone Idea. This video about the larger political structure, the bureaucratic structure, and the corporate structure that we have created for ourselves in this country, friends. So let's start. So the whole, the title of the presentation is Vodafone Idea's Possible Insolvency. So legal deadlock and policy paralysis. So this is a classic case of policy paralysis. So friends, I have spent 10 years in government. I know the ins and out of the government. Let me tell you this very clearly before I moved on to corporate sector. So I have seen both sides of the fence. So therefore, I'll tell you that what kind of problems that we encounter for ourselves, just because we need to create more flexibility to prevent any kind of perception externally to the whole world that we are creating loss for the exchequer, and our actions inadvertently seen as contributing to corruption, right? So we have to work. So when I was in government, I used to work 10 times much more, you can say, harder to manage this perception that, look, I have done everything to prevent any kind of perception that I am favoring a particular corporate entity, and still doing my work so that the government efficiency is not sacrificed. Okay. So it's a very difficult situation, friends, for those government officials who are working. So we need to give credit to them. is not that they have an easy task, because the situation is like that. The circumstances, the environment has been set like that. Okay, so let's look at the larger problem. Vodafone Idea's looming insolvency. We know Vodafone Idea may soon enter insolvency proceeding at NCLT. So what will happen? The secured lender may recover some value from physical asset like tower, equipment, land, because there are two types of debt Vodafone Idea is carrying. One debt is the government debt, which includes AGR and Spectrum. Another debt that Vodafone Idea is taking is from the private lenders, just like what you saw in this article. So this is a debt which they are going to take from private lenders. Now, when any kind of company goes for insolvency, the right of payment is to the debt holder. Then comes the equity holder. So whatever assets can be liquefied, then that assets, the money that flows from the liquefaction should go to and pay the debt holder first. So those secure lender, which are the debt holders, private debt holders, they may be able to recover some value from physical asset like tower, equipment, etc. But equity holder, who comes last, will get zero. So they are the biggest, you can say they lost everything in this whole insolvency because of this mismanagement. So equity holders are the biggest loser because they get nothing. But the largest item on the balance sheet, you can imagine if suppose somebody has to say that, let's look at the balance sheet of Vodafone Idea. So on side you have what? Asset, which includes plant, equipment, and spectrum. And other side we have liabilities. Liabilities are what? Liabilities are those cash items which are used to purchase those assets. Means what has paid for those assets. So balance sheet is always going to be like this. So let me just show you. So you have got this something like this, and this will be broken into two parts. So one part will be asset here and one part will be liability here, friends. So the assets are those physical entities or intangible and tangible entities which can be liquidated. So that is the whole fundamental, is that you can liquidate those assets because you have paid for those assets by either debt or equity, right? But strangely, the spectrum has a different category, right? It is an asset which you pay for, but you can't liquidate it. That's the basic problem, friends, we are facing with all our telecom companies. They are showing asset in the books, but those assets are actually doesn't exist because you can't liquefy those assets unless and until you have the money to pay for government, claims. And then you are given a little bit of, you can say, leeway to trade spectrum unless and until you have paid government's dues. So let's say if you have a large quantum of spectrum and all those spectrum has not been paid for to the government, then there is no way you can liquidate those assets, because the government will say that pay me first, because those spectrums are deferred payment spectrum, and then you can liquefy. So it does not mean anything because you anyway don't have the money, right? So now the spectrum trap. So let's look at the spectrum trap. Supreme Court AGR judgment in 2022, it's clearly said that any asset any company has, like spectrum, cannot be traded, which is owned by the way, spectrum is owned by the government. It is given to the company, right, for usage. So there is a right to use, almost like lease. But you can't have any ownership of the asset. You cannot sell the asset. And this issue is currently getting debated in the RCom case in Supreme Court, because RCom wanted those assets to get liquidated, and therefore the RCom case is not getting solved in the bankruptcy court in NCLT, and Vodafone is going to also face a similar situation. So therefore, the problem is that any kind of government debt or government payment which is due will prevent the spectrum to get either traded or liquidated. And even if the spectrum has to be liquidated, it will go to the coffers of the government to auction it, because you can't auction spectrum, right? A private entity doesn't have any right to auction spectrum. So Supreme Court judgment said that you cannot liquidate anything unless you have your dues are clear. For VI, what does it mean? Spectrum can't be liquidated. Now, so their biggest debt, which is the 2.2 lakh crores debt, where the private sector debt must be minuscule, maybe 5,000, 6,000 crores. And those debt that they are carrying is government debt, or certain portion of the debt which they took from private lenders have been used to pay off for the spectrum or AGR. Those debt cannot be liquidated because none of the asset which is there in the balance sheet on the right hand side or left hand side, this is the asset and this is the liability. So this asset part looks bulky, if you look at this asset, but actually it does not exist, because most of the asset is spectrum, right? Because the spectrum actually in India has been valued, in an unrealistic fashion. And that's why the spectrum auction in India, or the pricing structure of spectrum in India, is broken. I have been saying this from the very beginning. Nobody is listening. But one has to understand that the current problem that we are facing in India is not just because of AGR was mishandled. It's because we have not fixed the auction, the structure of auction, especially the pricing part of the spectrum, in such a way that the companies who are playing in the market, the weakest one is able to survive, not the strongest one, friends. Spectrum should be priced in such a way that the weakest player should find it comfortable with the pricing of spectrum. What is happening today is that the strongest player is finding the valuation of spectrum comfortable, because they are able to drive the weakest player out of the market. Because if the spectrum valuation is high, then it helps the strongest player, because once the market has been cleared out of the weakest player, then they can do whatever they want. They can get all the government packages which have come in from starting from 2021 actually has benefited the strongest player than the weakest player. We can clearly see Vodafone Idea is still struggling. So spectrum can't be liquidated. No buyer can use it unless dues are paid. The government dues are paid. Resolution will stall for years, like RCom and Aircel. So why RCom a case is still pending in SC and it still matters? See, if you look at the RCom case, it's a insolvency case which was being fought in the NCLT. So the lenders basically were arguing, saying that, look, RCom has some spectrum which is valued. Let those spectrum get liquidated, and let me just clear my dues by liquidating those spectrum, means selling those spectrum to those who value them, right? At that time, 800 megahertz band was quite valuable. There are certain blocks of spectrum in 900 which was valuable. Even 2100 megahertz was valuable. But the government said nothing doing. We are not going to allow you to liquidate because you please play for my dues, AGR dues and other dues. So the matter actually went to Supreme Court, and the Supreme Court is still have to give a judgment on whether spectrum can be treated as a true asset and can be liquidated, which I think is unlikely to come from Supreme Court, because the government has come out with guidelines which are so strong. Those guidelines cannot be circumvented. Spectrum cannot be treated as asset. Let me tell you, friend. Because spectrum is almost like a lease. It's like, if you're taking a shop on lease for a longer duration of time, and you have no right to sublet or sell those assets in case if you face bankruptcy. So you have to, and you have, let's say if you're paid for the lease upfront, then you're gone. So there could be two scenarios. One is spectrum paid upfront or spectrum paid in a deferred manner. So deferred manner, you can say that I can't pay. But if you're paid upfront and your lease is still persists for, let's say, 10 years, you can't do anything about it, because you cannot just say that, somebody please come, I get out and somebody please come and you can continue this lease. That does not work like that. Similarly, spectrum is almost similar to that. So the central legal issue is, can spectrum be treated as an asset under IBC and transferred in liquidation despite AGR dues or any other dues, government dues? So this case addresses a different question from AGR verdict, not about trading of spectrum during normal business, but about whether spectrum can be transferred under a court-approved resolution plan. The outcome may define whether the IBC can override DOT's due claims and unlock, and this resolution, if it is positive, then it can unlock a resolution for VI also. Okay. So the national consequences. So all this mess that we have created for ourselves, friend, actually has consequences for us. So therefore, the people at the top, not only in the government sector, but also in the corporate sector, should have the responsibility to behave in a manner that larger interest of not only their company, but the overall ecosystem is protected, because we are all responsible for the ecosystem. Let me give you an example, friend. Let's say if you're working for a company and that company becomes monopoly, and you have done everything to create or say a situation that the company turns a monopoly, because you have loyalty to this company, the company is paying for it. But what will happen, let's say after the company turns monopoly and they kick you out of the of that company. One day, the company may say that I don't no longer require your services. You come out in the market, and in the market you find nobody is going to take you, right? Because there are no jobs, right? So if a company or a setup company becomes monopoly, it is not the consumers which are getting impacted, friends. It is the employees who have contributed towards making a company monopoly is going to be the hardest hit. Because once you come out from the company, and because not married to a company, you can be thrown out anytime, you will not find any jobs. So it is not in the interest of anybody to behave in such a way that you create unfair situation for a company, and so the company becomes so powerful that they drive other companies out of business. So the consumers will suffer higher tariff, reduced competition. Creditors will suffer delayed recovery, shrinking asset value, right? And then India suffers spectrum lies idle. I showed you in one of my presentations that how much spectrum will lie idle. And those spectrum you cannot use because the litigation can go for years together. It can go for decades. So you have an asset which you have locked for yourself. You have locked a room of your house, which is the most valuable room of your house, and you can't use it. What kind of situation that we have created for ourselves? So the legal precedent blocks all practical options. So look at another thing, friends, very interesting. So who is fighting for what? What is the purpose of DOT? DOT's purpose is to preserve value for the exchequer. They don't want anything to be lost from the exchequer, and all dues should get recovered, right? So that is the whole purpose. And I am not doubting the intention of DOT to behave that way, because exchequer interests have to be protected. So DOT says that it wants to help VI. It is clear from that. No? VI has written to DOT, and DOT says that, I want to help you, but I can't because this SC judgment is an obstacle, right? So that's what DOT is saying. Yet DOT itself defends that judgment in other cases like RCom and RCom. So DOT has got two different roles. It is wearing two different hats. In one case, DOT is saying to Vodafone Idea, look, I can't help you because SC judgment says that any kind of waiver that you give or any kind of relaxation of payment that you give to Vodafone Idea to you, that is going to be contempt of court. Then in another case, which is being fought in the same Supreme Court, you are saying that, I can't allow RCom to liquidate this unless they pay their dues. So it is almost like the sarcastic analogy is like a landlord demanding full rent before unlocking the door, then claiming that they are helping the tenant to move. So you have a tenant, right? And the tenant is staying in your house. So what you have done? You have from the outside locked the door, and you're telling the tenant, look, so-and-so, I want to help you to move out of this place, but somebody is not enabling me to help you, right? But you are fighting in another battle and saying that, I can't unlock this door because your dues are not getting paid. So it's like a catch-22 situation for yourself. So DOT has got two hats to play with, and I understand why DOT behaves like that, because the perception that they want to create to the whole world that they have done everything to protect the national interest or the exchequer. So nobody can accuse DOT officials or those lawyers to kind of act in the favor of a particular corporate entity and cause loss to the exchequer. So you can imagine the kind of contradictions that we are creating for ourselves. So the deeper governance problem. So this is actually a deeper governance problem. See, this policy ambiguity is often deliberate. So sometimes what happens, because I was in the government and I have seen how it works. So sometimes the official will deliberately act to keep the policy vague to retain flexibility, because they won't be sure that what kind of situation may arise in future. So you keep the policy as vague as possible. And when you keep policy vague, those policies will always get challenged in the court of law because of ambiguity, right? So to retain flexibility, you want to keep policies vague. Then that will enable you to correct errors. Suppose, let's say, if you have not visualized something, so you can, if you have flexibility, then you can correct those errors, the DOT officials. But if you don't have flexibility, then you say, policy has been cast in stone, therefore I can't change anything. So people may accuse you, how did you create such a policy which doesn't enable you to correct those errors which you did not visualize? So therefore the flexibility is very, very important. Then sometimes due to lack of expertise, people don't understand. They will create policies with no understanding what is going on because they don't have the technical expertise. You need to have 10 times the technical expertise to visualize what is going to happen in future. The crafting of policy is an art. You can't just write policy statement like that. You have to weigh each and every word to see what the meaning of the word is and how this word is going to impact and how it can protect interest of both the parties, not just one party, because by protecting the interest of DOT, the larger interest is anyway not getting protected. We have seen in the 2G case, we have seen in the Vodafone case, we have seen in so many cases. It is actually self-harm the DOT is creating for themselves because they have created a policy structure which is so vague, where litigation is going on forever in the telecom sector and assets like spectrum is getting locked up. So because policy impact is delayed out of fear of being seen as corrupt, this is also very important because the officials' pension is going to get locked up and they fear that their pension is not going to be paid, and due to public blame culture. So you see the 2G scam. So 2G scam, the CAC came out with a report of 1,76,000 crores. Nobody looked at whether the spectrum under which the 3G auction took place actually can be imposed. The same condition can be imposed on 2G spectrum. There was only 3 slots for 3G. And there were how many bidders? There were some 10 bidders bidding for that. If you are going to have 60 megahertz of spectrum, which is how many times? 12 times more. Right? Then what 3G? Can you expect a similar kind of pricing outcome? So what kind of notional, you can say public perception is, right? Public perception gets carried away because most people are not economists. They don't understand. So it is our responsibility to make them understand. You can't be driving a narrative, right, with an interest of creating confusion. And once you drive a narrative to create confusion, you become victim of that circumstances because your hands get tied. And therefore, the spectrum prices went very, very high. So this results in long-term damage and short-term cover. That's all. So what needs to change? Codify rules clearly on spectrum usage and transfer. Protect honest decision makers from retrospective audits. Distinguish legitimate business gains from corruption. It's a very, very important. You can't be levying charges to every official that they are corrupt. Most of them are not friends. And let me tell you, because I was there in the government. There could be some few, you can say black sheeps, which are always there in corporate sector also. There are people in corporate sector in procurement, they take kickbacks. I know it for sure. So same is true for government, but most officials are genuine officials. They are honest people. They are victim of circumstances. They can't act because of all these allegations which get levied against them. So public is also responsible. Encourage regulatory courage, long-term thinking. So corporation is also responsibility. CEO should be stop fighting an endless battle with the government, right? Just thinking that, you will win the battle and therefore you put everybody in the government. So you have to be responsible. Otherwise, these kind of, pitfalls will happen. Litigation buys delayed, not resolution. Resolution always has to be focused on resolving the problem in a short window of time. Be pragmatic, absorb short-term pain, avoid long-term paralysis. Trust history. Dragging AGR battle only cost Telco dearly. Maybe few people have got benefited, but let me tell you, friends, their employees who have contributed to this outcome are the biggest loser, because once they come out of those companies, there will be no takers. Their salary increases will not happen. They will have lose leverage. So what kind of situation that we have created for ourselves? So the final thought, India doesn't lack capital or talent. It lacks political stability and coverage. Unless we change the governance structure or culture, spectrum will rot and get unused. Companies will bleed slowly, consumer will pay the price, and the employees who have contributed to this monopolistic situation, thinking that they have done a great job, one day, if they find on the other side of the fence, they will suffer because there will be no takers in the market. The market needs to be always competitive because it is the interest of all the stakeholders, friends. So that's all, friends, in this video. I hope that you like this video. And if you have any thoughts, let me know in the comment section and I'll come back with a new video next time on a new topic.